Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. All right. Well, welcome back to the Meaningful Mediation Podcast. This is the show where we talk with the lawyers, mediators, and negotiators who spend their careers negotiating for a living. I'm Patrick Russell, your host, and I spend my days as a full-time mediator, which means I spend a lot of my days listening to people on opposite sides of a table who are trying to find a number they can both live with. Today, my guest is Michael Beckman of Viles Beckman in Fort Myers. He is a plaintiff's personal injury lawyer with more than 2 decades in Florida courtrooms and someone whose path in this work started, of all places, on a theater stage. He's tried, settled, and led on cases that have produced landmark awards in this state, and he runs a firm that thinks hard about how clients are actually treated. Michael, welcome to the show.
Thank you, Patrick. It's great to be here. Thank you for having me.
My pleasure. I'm so happy that you were able to make the time to speak with us today. So before we get into how you negotiate, I wanted to start somewhere where most lawyer guests don't get asked about, the road in. So I found it unique as I introduced you about your studying theater at USF before you ever thought about law. So when you look back, what skills from that world have you actually carried over to how you negotiate a personal injury case?
Yeah, you know what? It's funny with theater, it definitely helped me more comfortable speaking in front of audiences. For a lot of people as attorneys, outside of the strategy and everything else that goes into putting together a trial, just that comfortability of just being in my own skin. That's where I think it helped, because I'm a strong believer that you're only going to be able to negotiate as well as the other side knows or is afraid or has, the information that you will in fact take that case to trial, that you're prepared for that.
And I think that maybe you'll agree or maybe you won't, but it seems that a trial is in fact a theater, isn't it?
Yeah. It's so funny. You have an audience, you have the jury, you have the critics sitting up in the booth, you have the judge, they're there to, rule on objections. But yeah, it really is. You get into the courtroom and everything is a theater. The only thing I would say that's different between being in the courtroom and being in theater, when you're in theater, you're playing a character. You're getting into somebody else's role. In the courtroom, if you're not yourself, if you're not authentic, the jury is going to be there. Most people coming on juries, I think they already have that hidden sense that, they're there to basically detect whatever BS there is, whether it's on the plaintiff or the defense side, and then come to a verdict how they see fit. But if you're not authentic with that jury, I think that really hurts you. So I think that's the big difference. The one way it does work is you do need to understand your client, especially from a plaintiff's personal injury, because you're presenting yourself to the jury on behalf of your client. And for that jury to understand your client, to know how an accident, a tragedy has shaped or changed their life, or a loss of, they lost somebody they loved, you've got to be able to get that empathy across to the jury, that understanding. You've got to get that they're not supposed to take sympathy into effect, but we all know that. They do what they want. You have to be able to get your client across them. So in that effect, you are playing your client's role in order to get across what your client needs that jury to understand.
And a jury trial is a drama though, too, isn't it?
Yeah.
It has its ebbs and its flows. There could be heroes. There could be villains. There's the arcs of that going up and down.
Yeah.
It's very similar.
The funny side is, funny thing is, 2 attorneys that both believe that they're the heroes and the other side's the villain. No attorney goes there thinking that they are they're the villain in the case. They're the hero. If you're on the plaintiff, you're the hero. You're the victim that's been suffered. If you're on the defense, you're the hero fighting for the person that's, being sued that shouldn't be sued because this plaintiff's attorney. So everybody looks at that. But yeah, the jury as the audience, much like in plays, sometimes, a writer might believe that they're writing something for someone to be the villain, to be the hero. Sometimes people fall in love with the villains in plays. Sometimes, they fall in love with the villain. So sometimes if the jury believes you're the villain, it's not always the bad thing. So yeah, so you do definitely have that drama aspect to it in the courtroom. Once again, you have the judge there as the critic to pick everybody apart as to what they're doing. So yeah, it's definitely there's a lot of drama. And like you said, Patrick, the ebbs and the flows of the trial and the things that people, you go to a play and you don't if it's done well, you're not going to see the mistakes that the actor might make or the production crew makes. And when those mistakes happen in theater, you've got to be ready to pivot. You can't just stop the play, and if something falls out, you just got to do it. As you know, as a trial attorney, trials are no different. Something can go wrong, and you just got to take it in stride. You just got to take it absolutely in stride. And you got to be ready to just pivot right there, right then, and not let the jury know that that wasn't supposed to happen.
It's like improv.
It is. It's very much like improv. Yeah, yeah. It's very much like improv.
So, plaintiff personal injury work is fundamentally a negotiation business since most cases end up settling.
Yeah.
So, when you take on a new file, at what point do you start thinking about how is this case actually going to settle versus how are you going to try it?
So to me, those two things are indistinguishable. What I try to teach my young attorneys is that when you're negotiating a case, let's say pre-suit now, when you're negotiating a case pre-suit, you've got to negotiate that case from the standpoint that you could file on that case any day and just be ready. Because when you're talking to the adjuster or if they hire an attorney pre-suit, when you're speaking to them, they've got to know that one, you know your facts. Two, you know the warts of your case, in addition to all the rainbows that you can sprout about your case. That you know that case better than them and you're ready to file a lawsuit. That gives you, and that's, what I've learned over time, that gives you superior negotiating power when it comes out, when you're dealing with an insurance company or a defendant looking at it from, I've never done the defense, so I only can speak from a plaintiff standpoint, but from a plaintiff standpoint, if they don't know you're ready to file suit, and then when it comes to trial, once you're in suit, I tell my attorneys, settlements will happen and they will happen for higher value for your client if you are preparing that case for trial the entire way. You're not missing deadlines. You're hitting all of your discovery. You're taking your depositions. The defense attorney sees that strategy unfolding in front of them because they're going to have a candid conversation with the adjuster. Listen, this team is ready to take it to trial. It's not, because insurance companies, I know lots of insurance adjusters. They keep track of which law firms try cases, which law firms don't try cases. So they got to know that you are that law firm that will take that case to trial, no matter how crazy the facts. If you have it in suit, you didn't put in suit to settle it. You put in. To me, I've always found that helps tremendously when it comes to negotiating power. So to me, they almost can't be separated, but they are separated because, inherently trial is a huge risk for your client. If they lose everything. They're not an insurance company. If they owe attorneys fees and costs, that could bankrupt them personally. So you're, in your head, you're looking at that strategy for settlement for your client. But as far as the other side sees, they see that when you're talking about settlement, this is what it needs to settle for, or we're taking this all the way to trial and we're ready. We're ready right now. Want to notice the case? Let's notice the case together for the judge and tell them we don't need any more discovery. Yeah, it's a year, docket, but we're all ready to try this case now. Let's get it done. So yeah, I think it's, that mindset is extremely important when it comes to negotiating.
Awesome. And I've seen from your background, you've mentioned that you've got some pretty hefty verdicts in the 35 to $40 million range. So without getting into anything that's confidential, what do those kind of cases teach you about negotiation that maybe smaller cases don't?
Yeah. So, the 35 million, I can't go into the settlement that happened after that jury verdict, but I can tell you that was a quadriplegic drunk driver, that we wound up, being able to make sure that woman was taken care of for the rest of her life. So when you look at that versus a case, let's say somebody might not look at as being worth as much. I believe it's your job as the attorney, because when people are injured in auto crashes, okay, you want all their medical treatment to be genuine, right? You want to be able to put on a genuine case in front of the jury. But there's things people don't realize. There's things that people don't realize that juries look into, like if a person stops treating for, 90 days, how does a jury view that? The defense calls it gaps in treatment. I always look at the jury and say, hey, life gets in the way. People have to work and whatnot. Depending on the six people, depends on which side they believe on that argument. But, you want to make sure that for those, smaller cases, that don't have the value of that don't have the same losses as somebody with a severe brain injury or quadriplegic or death might have, that they are themselves, getting to the doctor so the doctor's able to document their pain, their, what's going on in their life, whether or not their pain's improving, whether or not it's getting worse, whether or not the symptoms are staying the same. So the jury has that evidence to look at, to say, yes, this person really was her. This person's pain just didn't go away, other than it just being your client's word that the pain didn't go away. Because whenever, you're dealing with negotiating, whether it's with insurance company or if you're in trial in front of a jury, there has to be evidence that your client did have ongoing pain, that these symptoms are real. And your client's asking the jury for money. And that right there, somebody asks you for money. If some stranger asks you for money, your first reaction is, whoa, slow down. Let me get the facts before I just write out a checkbook here. Regardless if it's coming out of the jury's pocket, it is coming out of the insurance company's pocket. So they will be looking, for negotiating, whether or not your client has a real injury. So you want to make sure, your job as the attorney is to make sure that, in order to get your client the value that their injuries do demand the justice for, that they are keeping up with the treatment, and that they're, they are going and they are making sure that that evidence is proved, that they gather their lost wage information. So you're not just putting up some crackpot lost wage. You can actually show the jury the numbers, calculated what they lost and why they lost it.
You and I had a history
Yeah,
where I was on the defense side briefly.
that's where I first met you. Crazy case. I can't, we can't go into what eventually happened with that case due to confidentiality, but it was definitely a crazy case.
But at the same time, I can concur that with what you just said, that I think a lot of defense lawyers and obviously adjusters as well will look at the medical treatment, and that's just a major red flag where if you have huge gaps or very little follow-up, it doesn't seem to be a very serious injury, or otherwise normal people, if they're in pain and they have a problem, will definitely seek treatment, right? So if you're not doing it, and I think that's an easy sell to a jury, just saying that. So I think your point's right on that if you want to have your medicals taken care of, you should be following up. But let's switch over back to the mediation side now.
Yeah, go right ahead. Yeah.
So from the plaintiff side, mediator selection can matter a lot. So what do you actually look for in a mediator in a personal injury case? And do you ever push back when the defense suggests somebody?
Great question. So, I use you for mediations, and one of the reasons why I'll just, in this kind of give you my mindset, one of the reasons I chose you is because, I was very impressed with your skills as an attorney, your professionalism as well. I always look for professionalism, and I look for somebody who is a skilled attorney, because if there's going to be an insurance company that's going to, that I need to get more money out of, I can't send somebody, I can't have a mediator that, the insurance company is going to have, zero respect for, their opinion. So, I look for people who who I litigated against, I respect, and there's quite a few. Most of the people I use for mediators are defense attorneys. Now, I will say there aren't many plaintiffs attorneys that go into mediation, but there are some, and I will use them as well. On the second question about pushback, you know what? I put names out there, and generally the names I put out there most insurance companies like. If there's somebody who they specifically want, I'll look at him, and if it looks like it's somebody that has experience, I'm actually fine with it. If it's somebody that, in my mind, if it's somebody they're comfortable with, okay, if that mediator is doing their job and, they will go over there and say, listen, you have some problems. You may not be looking at this right. Cause you've gone in the room, whether it's with plaintiffs or, the defense. I'm sure at the plaintiff, you're in there telling them, why on these facts, they probably aren't going to get the money they're looking for. You as the mediator, I'm sure is there with the defense telling them, listen, I'm looking at this issue. If I was sitting on the jury, this would be an issue. This would be an issue. This would be an issue. So it's a mediator that they choose, unless it's somebody who I've used, who I thought is not good with my client or is, just would not mesh with my client personality wise. Cause that's something else to look at, whether or not I believe certain mediators, because there's some of my clients that if you have a strong willed mediator that pushes a lot, will not mesh with that client. But then there's some clients that need that strong willed mediator. So I will look at personalities. With the insurance, with the insurance adjuster, somebody they're comfortable with, somebody whose advice that they're going to listen to. I'm generally going to do it as long as a few things like personality clashes with my client. I'll take into effect. I'll say, listen, can you give me somebody else? I just don't think this person will work well with my client. So there is thought that goes into it.
Okay. And back to the personalities of mediators, do you ever have a sidebar with the mediator and say, listen, expressing that concern, maybe I need a little help, or maybe you need to be a little more forceful, maybe you need to have a lighter touch. Do you ever give a heads up to the mediator in advance?
Yeah, if it's a mediator that I know real well, call them or shoot them a text or let them know that my client, listen, my client's a really good person. Sometimes you come in a little bit hard. You may not want to do it with this lady. It's not going to work with her. It's gonna just upset her, and I don't want to see my client upset. I'll do that because my first thing is to make sure my clients are protected. And if I know it's a mediator that just a little bit rabid with people, and sometimes listen, there's some clients and I'm like, yeah, that's gonna be a really good mediator. This client will react well to that mediator. Some people just want a no nonsense mediator that just tells them what they think and comes right out no matter how harsh. And some people and I have clients that, that language works for, that's their love language. But there's some clients that, it just won't be effective. I think for mediation to be effective, my client has to be willing to, at least, not trust me because the mediators can't give advice, but at least trust that, when the mediator says that they're looking at something a certain way, that's genuine. And I'll tell you what, if that personality off puts them, my client isn't going to care what that mediator says. So, I think for mediation to be effective, sometimes it's good, to let them know, hey, be a little bit easy on this person.
And there is no one size fits all, is there, for mediators? A mediator could perhaps pivot between those two different worlds, but each case requires probably a different skill set.
Yes, it does. Too, in it, there's also specialized, mediators. There's some mediators that only handle excess judgment, bad faith cases. There's some mediators that specialize in medical malpractice, and they're the go-to for a lot of hospitals, the doctors and the plaintiff medical malpractice, nursing home and nursing home and medical malpractice attorneys. So yeah, I mean, you get that just like in practice, you get that with mediators as well.
So getting back to your clients,
Yeah.
often when you're representing them, they're going through the worst stretch of their lives. So how do you talk to your client about a settlement number versus a trial number, which often can be very different?
Yeah. So, when we're there, we're going to negotiate hard. When that insurance company comes to what they say is the bottom line, and of course we don't believe them, we always try to fight for more. When it's the absolute bottom line, I think a client needs to know the risks. I think that's probably the most important thing. They need to know the risks. Say, listen, this is done in a form of proposal for settlement. This is sent to you and you reject it. Here's the fees or the cost or whatnot. Here's how much I've spent so far in your case. Here's how much more I anticipate you spending before trial. So if we get, here's the different numbers. We might get more at trial, but if we don't get more than this, you're not netting more. So for me, uh, you know, we're the 5-star law firm at Viles and Beckman. One of our 5-star points is that we're always going to be transparent with clients. That's one of our 5-star promises to all our clients. We have certain promises, that we give our clients, and that's one of them. So I think the only way to truly be transparent with the client when you're looking at settlement numbers versus trial numbers is honesty, transparency, saying, we could get this a trial, but let's say we get this. It's very much a risk analysis at that point. So I think with the transparency and, getting some clients like, hey, listen, you know, they can't get blood from a stone, take it to trial. If we lose, I understand we may not get that number. I'm willing to risk it because that's number one. What they're offering today doesn't make up for. There's other clients that look at that risk of like, okay, so how much is it going to cost to get the trial? Because right now you've spent 5,000 in cost, and you think it's gonna be about another 50,000 in cost. So I'm going to need to get another 50,000 on top of what they're offering now, just to pay for those costs if we take it all the way through trial. And I have to explain to them, yeah, probably get some of the costs back as taxable costs, but not all those costs are taxable. So I have to explain that to them, we're not going to get 100% of those costs back. So be prepared. You're going to still get hit with costs. So, they have to go through that type of analysis, and then they'll look at it and say, you know what? Yeah. So they're here. Let's try to get into here. If not, shut it down for this, whatever the client's thinking on that risk, if they're a little more risk averse based on the numbers, then we'll sell. But a lot of it's transparency to the client.
Yeah, I think that's excellent advice because going through, let's say, a mediation and you're offered a certain number and the client balks after that type of a conversation, and you go through trial and you end up netting that same exact number, let's say, after all the costs. That's not a real successful outcome when you could have resolved it a year before, right? And took the risk that maybe you've could have did worse. So yeah, those type of conversations are critically important. So now you've been doing this work long enough, I would assume, to have a few cases that changed how you practice. So most lawyers have one, right? Something maybe early, something in the middle, whatever it may be, or maybe even recently, that may have perhaps rewired how you approach practice of law and how you do things. Tell me about one of yours. Tell me about a defining moment, so to speak.
Sure. I might have a different defining moment than most attorneys because mine wasn't so much a case. Mine was when I had a case leave me. Okay. Um, and for that case, that client didn't feel like there was enough communication. Now, I thought there was, and lots of attorneys think they do. So, one of the things that we did is we changed everything and the way we do things. We got a case management system that allows us to email, text. The clients can text into us. The clients can constantly communicate with us. And, my business partner passed away in July 2023. But one of the things he and I were talking about is that we wanted to be the Ritz Carlton of law firms with regards to service. Okay. When they come to us, it's not Motel 6 service, and nothing wrong with Motel 6. They're a great chain, but there's a difference in level of service you're going to get at a Ritz Carlton or Four Seasons compared to a Motel 6. So, we started taking things more from a client perspective, and looking at clients' needs. And when he passed away in 2023, I became the sole owner, and my COO and myself, we developed the 5-star promise, and we developed a lot of different things to make sure that clients aren't just priority, but we must provide exceptional service to them. We changed the vision of our firm. We changed the mission of our firm. We changed our core values. We changed so many different ways of our operations, our processes. Everything we did was to make sure that the client got exceptional service. Exceptional service is one of our core values. So losing a client and finding out that they didn't feel like they were being communicated with, that was a turning point for me on how I run the business, a law firm business, as opposed to just being a very, just being a great trial attorney. It was, that aspect of it is like, they need to be better. Well, I always tell people when they call into our intake department, for the size of our firm, the amount of Google reviews we have is a lot for the size of our firm. We're not nationwide. So, but for, a local firm, we have a tremendous amount of reviews, and our reviews aren't like one lines like good attorneys. We get those, right? We get a lot of those, but we have a lot of reviews that are paragraph long, War and Peace type novels. We've created a culture with our team. Our team, when somebody comes in day one, We just don't sit them at a desk and say, "Here, start case. You were a case manager in the past. You're entirely here's your caseload." They actually come in and they're actually trained on our culture. And our culture is providing that 5-star service to the client. Our vision is to be the cornerstone of advocacy, generosity, and exceptional service to change the lives and the communities we handle cases all over the state of Florida. So, with that vision, a lot developed out of losing that one case, a lot developed out of that. So it changed our complete, business practice on on how we do things, how we develop. So it just a it was a case, but I don't think it was the way you're asking. You're asking about how did the ebbs and flows of a particular case change it. But to me, that was actually very impactful. And now I'm so proud that when we represent people, we, provide great legal service, of course, but we also provide that personal service to the clients. I go on and on. We do celebration surveys for the clients. So if something happens special in our life, we know what type of gift fits their needs, not just a generic, just not something generic, but something that means something to them, actually
Right.
means something to them. So we do that with our team too. It's, we know that somebody in our team, massage is something they like. We're not going to send them a gift certificate at a restaurant. They're going to get something to a spa, for something they did well or for their birthday or whatnot. That personal experience is just, that bleeds through our culture. And that's, why we're, the 5-star welfare.
I love that because that demonstrates that you can better yourself even through a less than optimal result. You don't always grow when you succeed. Oftentimes, you grow when you have a setback and you actually come out on the end at a better place. And if you're not learning, you're not growing, right? So I think that's an excellent example, in fact. So
Yeah.
thank you for that. That's a good one. Let's switch over to what I call this segment as the mediation toolbox.
Okay.
All right. And so this is where I've got 4 questions for you today about what you bring into mediation as a tool, so to speak.
Yeah. Okay.
So when you walk into a mediation, what is the one thing that you always do?
One thing I always do is I make sure that my damages are charted out, that they're explained. So when the adjuster sees them, they see how I'm going to get the jury to what number I'm wanting. I will show them how I calculate the pain and suffering. Show them how, the meds, the future meds. And I put not just the numbers, but I put underneath all the types of support I have for each one of those levels of damages. And say, listen, I'm going to walk the jury through these damages and they're going to get there. And here's how. So that's one thing. If you're asking about one thing, because, mediation and how you prepare for each mediation changes. But that's something I would say that's consistent is that presentation of damages.
Yeah, I would say that probably nothing worse could happen if you just throw out an arbitrary number with no support. People can't really comprehend or think about how to deal with that. And it just seems like it's made out of thin air. And good luck trying to get that. So, being able to point to certain things and lead people with a roadmap of how you got there, I think is really important. So, good one. Here's a second question. What tool, technique, or move do you use that perhaps most lawyers on the other side don't see coming?
Okay, so I'll out one of my secrets. I don't give round numbers as offers.
Okay.
I can't tell you how many meters have told me that they're discussing over there. They're spending most of their time discussing how they came to a particular number. Like I just don't say, yeah, we want $200,000. My number will be something like $207,839.86. And I do have a way that I calculate that number, so I don't pull it out thin air. But when I give the number, it's never a round number, and it keeps them thinking. And the funny thing is, what actually gave that idea to me is I got tired of seeing all those letters from Allstate. They put it through their computer program. They'd always spit out, these numbers, down to the penny. So I figured, why not? Why don't I give them numbers back down to the penny? Let them digest that. And I've been told by mediators that it actually has an effect. So I do it.
Well, you said it yourself, it gets them thinking.
Yes.
And that's the most important thing that you can have going on in the other room is people thinking about that. So, good one. So, what is something that perhaps you used to do earlier in your career that you don't do now? and what replaced it? And again, for mediation.
For mediation, bombastic, over the top.
You toned it down a little bit.
Yeah. I learned how to. I had a friend that was a mediator that one time took me aside. It's okay to be, to fight hard for your clients, but you got to tone back some of the. So yeah, so I definitely early on, to me fighting was just that inner beast, because I played sports my whole life. I know I'm a theater background, but I'm actually a huge jock, and I've played every sport there is. Imagine team sport, out there. I have played individual sports like tennis and golf, but growing up, baseball, hockey, football, I even played rugby in college. So to me, it was, go out
You
and
have that competitive
I was
spirit.
Polish. I have that, that ground. And my business partner too, who took me in as an associate, we went on to becoming partners. He was very much like that. Now he was an economics major, not a sports guy, but he had an edge to him, and he was. So you had two of us, and that was, So I had to learn how to tone that back for mediation. That's not what's going to get me the money for the adjuster. And I've learned that, adjusters are people too. They don't want some snot-nosed young attorney coming in there like some, cannon that's just firing off everywhere. They truly want to know what you're going to do and how you're going to beat them at trial, whether or not they believe you can, and they have families. This is a job for them as well. They're, their job is to do it. They have, wives, they have husbands, they have children. There's no reason to personally come in and just come and attack it. Show them why you're going to, completely destroy them at trial, why they're going to lose. And you can do it respectfully, where you can shake their hands afterwards if you don't come to an agreement, and you can, afterwards, asking how their kid you're going to ask them. And I've learned, when I was younger, didn't realize it, but as I grew, you catch more flies with honey. It's, and I learned that with defense attorneys too. Like by the time I had that case with you, I was a completely different attorney. You and I had a very professional,
Thankfully.
we had a very professional relationship. And, that was a case with a lot of difficult issues. And you and I were fighting hard over the issues. But that's what it did. We were fighting for our clients hard over the issues. We weren't fighting each other, as people. And, for mediation, that is something I've learned, that the people on the other side, they have families like you do. They have children like you do. This is a job for them like it is for you. And their job is to make sure you don't win. Your job is to win. We all have different jobs. Had to learn that, early on. That was a big mistake I made in mediations.
Well said. So, what is one book, person, or perhaps experience that has most shaped how you now negotiate?
Wow. There's a lot of books. I would probably say David Ball on damages. I'm sure you read that book. He's a juror consultant. Presenting damages. It was always presenting damages well, but a lot of things he says from a cycle. A lot of it's for jurors, but it's just as important in mediation because the insurance adjuster on the other side. Like I said, I show the damages. And one of the things David Ball talks about, you can't just throw numbers out there to the jury. You've got to show them how you get there. And so I would say for negotiating, that was definitely an impactful book for me. I think plaintiff and defense. That's a great. I know it was written more towards plaintiff, but it's a great book for the defense too. To kind of if you look some of the stuff he does, it actually can apply to defendants in voir dire. If for asking questions, very good book. But for negotiating, I think how laying out that damages and that story to the adjuster. Adjuster to me is no different than a juror.
Yep. They're a juror with a checkbook. Yeah. All right. So now we're going to move on to your top 3 tips for better negotiation outcomes. So if there was a younger lawyer listening to this on their drive home, what are your 3 top tips for getting a better outcome at that table?
Starting the case from the day you sign it as if you're going to try the case. If you do that and you develop your strategy and you keep that strategy throughout, by the time you get to the mediation, mediations when you're in suit, by the time you get there, your cases, you have something lock solid that you can you can present to that, to that insurance company. And it gives the mediator ammunition that they can take into the adjuster. And it allows that insurance adjuster to see that, you know, you're ready on this case. And I think that would definitely be one thing that I would tell somebody. Number two is visuals. We don't
Mhm.
really speak about this. I, our firm's always been ahead on technology. Like I remember a couple of years ago, we were at something and, they asked, entire room of attorneys down in Collier County. There was a CLE, a professionalism CLE that was all day long. And they were talking about AI and, they were asked, about AI. The only two people that raised their hands to say that they use AI are my associate and myself. And I bring that up because when COVID hit,
Mhm.
there's a lot of attorneys that had no idea what Zoom was. I mean, for me, I was already using Zoom. I was already, and attorneys that had cases against me knew what Zoom was. But I knew how to share exhibits. I knew how to draw on exhibits. I think presenting visuals are huge, especially on premises liability cases, slip and fall, trip and falls. I have, for instance, if, I have this raised sidewalk and notice is an issue and when somebody trip and falls. So I went back because Google Street Maps is incredible. You can actually year after year after year, they'll take, they'll beat out tree every so many years. You can actually see when they put that tree in, how it grew and how that just raised over the years and how it stayed there. So we were able to, once I showed the county that notice, that case solved. And I was able to
Mhm.
do it right there at the mediation. So I think using visuals, knowing how, not just using them, but knowing how to use them, how to draw on them, what order to put them in, don't, have your, either put it in a PowerPoint so, you're ready to go through or have your tabs open where you can just go from one visual to the next and you have a nice thematic flow to it. So I think that is huge in mediations because it gives, once again, the mediator something to look at. So they can go back and they're armed to talk to that adjuster. And that adjuster, they may have been thinking it one way. And now, if they don't have the authority, they may need to call for the authority and say, listen, I'm watching this presentation and I think we're going to lose a liability. We spoke about this case. We were talking about, that there's no way they're going to show notice. I'm telling you, they're going to show notice here. So I think visuals, it just paints a picture. It's look at that. And I guess the third thing is if you're looking
Well,
at,
that's just another part of
yeah,
storytelling, right?
yeah, it's just another
Words, its actions, and images.
images. The third thing I would say from a plaintiff's perspective, I don't know so much from a defense perspective, but view that insurance adjuster. You don't view them as the adversary, view them as the juror that you got to prove your case to. You've got to show them. Now, does that mean you show them every bit of strategy you're going to use at trial? Absolutely not. You can give a presentation and not give up, the strategy, but you can tell that story to that insurance adjuster thematically all the way through, down to your damages and what you're gonna show the juror. If you want them to, where they're offering you 50 and it's a 250 policy and you want that 250 policy because your client's been injured, show them, tell them that story from start to finish. If they're offering you less money because of liability, walk them through, and you use the perfect word, storyteller. Walk them through that story, as if they were a juror. So you can make sure that if they don't have that money, they're on that phone getting that money, before that mediator even walks in the door. And, a fourth tip, I said,
Ah, bonus.
treat them, be professional, realize that the people on the other side are doing their job, treat the same way. And I always let my clients know ahead of time, listen, I'm not going to come in here and I'm not going to be cussing them up and down, and this is something, this kind of fits in. Make sure your clients, especially if you have a plaintiff client, that you're going to be respectful when you're speaking to them and they're going to be respectful when they're not speaking to you. And if they're not respectful to your client, you will tell them to tone it down. You will stick up for your client. But, let your client know that, listen, this is a professional setting. This isn't where you go in and maybe when I stood first round practice, I would do this, but, this, this is not the form where we go in and, we come out all angry and this, we're here to present the case. And if they don't offer us the money that we don't like, we just take it to trial. So
Mhm.
what? You don't like the number, you don't like the number, but we don't have to attack them. I work with these people all the time. I work against them. I fight out against them. I go to trial against them. And I can tell you right now, if you want to get that 250, this is the way we get it.
Yeah. Well, I
So
think that,
I gave you a fourth and fifth bonus tip there.
yeah. Well, back to the third about the adjuster being a juror. It's an
Yeah.
interesting one. When I worked, and I primarily worked on the plaintiff side until the end where I was on the defense side, but I always looked at the adjuster as someone you just need to show them why to write a check. You don't give them a reason. You don't
Yeah.
even need to prove it to them, but give them a reason where they have to put it in a report and somebody else has to make a decision. Well, what do we do about it? But if you leave a lot of blanks
Mhm.
and going back to arbitrary numbers or lack of support for damages, lack of support for liability, not having the pictures that show connect the dots from A to B to C, the more questions there are, the less likely you're going to get that check, or the check will be much smaller, right? So if you can give them a reason, normally that's all they need. And so I think that's kind of the job on a plaintiff side is if you want the money, give them a reason.
I agree wholeheartedly. They've got to have that reason. And some of them want to close their file. But if you give them the reason to close their file, they're happy to write that check, but you got to give them that reason. You're absolutely right. That reason is huge.
Well, Michael, this has been a fantastic conversation. Thank you so much for your time. There's been a litany and even some bonus golden nuggets that you shared with us today, and a lot that we can all learn from. So, for the listeners who want to find you, the firm, where should they go?
Yeah. Vilesandbeckman.com is our website. We have Facebook, we have TikTok, we have Instagram. So I also do a TikTok live show. Right now we're doing it Wednesday mornings at 9 a.m. We talk about legal cases without the legalese, and it's fun. We sometimes go around and poll people. We have spin the wheels. We have a money gun. We do a lot of fun things that, for people on TikTok that are watching. So we can learn about the law, but it's not a boring law school professor type of way. Well, it's a lot of fun. So we've had fun creating it. And so look for us on our TikTok live show. Right now it's Wednesdays, 9 o'clock in the morning. Sometimes we have to shoot it at night. That depends on my legal schedule. So it's a good way. But Viles Beckman Facebook, Viles Beckman YouTube, Viles Beckman Instagram, Viles Beckman. And vilesandbeckman.com. Those are the best ways to find us.
Fantastic. Well, if you enjoyed this episode, please hit follow on Spotify, Apple Podcast, or wherever you listen. And if you're watching on YouTube, subscribe and drop a comment if you like the show. So this has been the Meaningful Mediation Podcast. We will see you on the next episode. We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.